Welcome back to Inside Politics here on KTN News. Now, less than 24 hours after the judgment that nullified the clamor to change the constitution through the BBI process, the BBI Secretariat vowed to appeal against the decision. Secretariat co-chairperson, Suna East Member of Parliament Junet Mohammed, announcing that they will move to the Court of Appeal, vowing to fight to the end to ensure the constitution is amended. KTN's Ibrahim Karanja has the details for us.
When BBI Secretariat co-chairs Junet Mohammed and Dennis Wawero, flanked by proponents of the Building Bridges initiative, among them Jubilee Party Secretary General Raphael Tuju, appeared to give a statement, it was clear that the team was not willing to go down without a fight.
Yesterday, the High Court of Kenya pronounced itself on issues raised by a number of petitioners. A section of the political class and non-governmental organizations, NGOs, have tried to stop Kenyans from having their say on the BBI by way of a referendum. These are beneficiaries of the status quo who are determined to stand on the way of reforms. This is the unholy marriage between Tanga, civil society, and a section of the judiciary.
The team referred to the judgment as judicial activism aimed at plunging the country into a constitutional crisis, further alleging that this was a plan from some political quarters and also pointing an accusing finger at the civil society.
As law-abiding leaders, we respect the decision of the court, but we don't agree with it. Consequently, we are setting up a legal team to look into and appeal the ruling. In the meantime, we assure all Kenyans who believe in the BBI and its promise not to give up. It is not over yet. We still believe a new Kenya is possible.
Indicating that the push for constitutional reforms was far from over, their secretariat vowed to move to the Court of Appeal next week and challenge the ruling, citing an inconsistency by the High Court. Their task force also indicated that the judiciary had watered down the ruling into a personal fight with President Uhuru Kenyatta.
This was a very deliberate design to plunge the country into a constitutional crisis and chaos through judicial activism.
The attack was on His Excellency the President, of whom Mr. Ngugi was calling Mr. Uhuru Kenyatta. He couldn't even recognize him as a president at all. So their main objective was to attack the president. That has nothing to do with the BBI.
Wataalamu wetu wa kisheria wapate nafasi ya kuchunguza kabisa uamuzi ambao ulitolewa na koti. Alafu watu julishe tutaelekea namna gani tukienda mbele. Public interest. Manufaa kwa umma ni nini? Hata tu wakitoa uamuzi ni lazima watoe wakifikiria mambo ya public interest.
Ibrahim Karanja, KTN News.
Thank you, Ibrahim. So proponents of the BBI are moving to the Court of Appeal to challenge this ruling. Cherotich, the BBI co-chair, Secretariat co-chair, Junet Mohammed, they are talking of judicial activism and accusing this of being an unholy marriage between the civil society and Tanga. What do you say to that challenge of let's meet in court?
Well, first of all, it is their constitutional right to appeal. This is why we have the rule of law, so they are able to. It is within their rights as citizens of this country. But the very tired and worn-out story of the Tanga Civil Society Alliance is one that we have grown used to, and we have been told that we are here running some kind of agenda for the Deputy President. The first thing is I've never heard the Deputy President pronounce himself on BBI. I never heard him say no to BBI. The only groups that said no to BBI were Linda Katiba. So this idea that it is impossible for citizens of this country on their own to rise up and say no, minus the political class, is one that we need to keep pushing back on and debunking. So by all means, they can go to the Court of Appeal. But for me, what I'm interested in is the timing. Because if this entire hoodwink was around succession, was around mutilating and massacring the Constitution of Kenya prior to the elections in 2022. When will they get all of this done? because the appeal process will now be an animal on its own and will proceed and will take its time. And by the time we've responded and submitted and all of that has happened, where will we be? So I even think that we have already, or they have already, appropriated 16 billion shillings of my money, of our taxpayers' funds, to run this unconstitutional, unlawful process called BBI. What monies are they looking for, therefore, to continue this process? Are they going to dip into their personal pockets now, their bank accounts, or will they continue to pilfer state coffers, to continue to push back on an extreme illegality? So as a citizen, as a tax-paying citizen, I look at it and say, are we going to stand back and continue to watch the impunity that led to this criminal enterprise called the Building Bridges Initiative? Whatever flowery reasons around peace, love, and unity that they were proposing in the Building Bridges Initiative, tell me one thing that needed a constitutional overhaul to implement, besides succession matters. Changing the structure of the executive, changing the structure of the legislature, mutilating and destroying the independence of the judiciary. Those were the underlying things they were trying to do. Everything about shared prosperity, etc., etc. Article 43 is very clear. Our economic and social rights are enshrined and upheld within the Constitution, Ben. And so when you look at all of these things, you say, can you just please, Junet Waweru, the entire BBI group, can you please cop a mea culpa and step back, stop wasting resources, unless we are seeing that you're paying for it out of pocket, and let us focus on what we need to focus on as the people of Kenya. We're impoverished. We're in the middle of a pandemic. BBI was not, has never, and will never be a priority for the people of Kenya, especially because the ultimate objective is nefarious. It is a hoodwink. It is a Trojan horse. Right. But by all means, let them go to the Court of Appeal. But I am saying here categorically that they must stop using my taxpayers' money to prosecute a matter in the name of Wanjiko when it is ultimately about succession.
Mark Bichachi, the number of times, I could not count the number of times the 5 judges used the term unconstitutional in that ruling, in that entire judgment. It was a very extensive judgment. Do you really believe that it can be set aside wholesomely? And number 2, there's a group of Kenyans advising proponents of the BBI to try and push things like the 35% monies to the counties through a parliamentary process rather than trying to appeal this one. Your thoughts?
Ben, you've asked two critical questions. And the first question is the question about the unconstitutional nature of how the president acted. And of course, the fact that then the courts went on to say that the president can be sued in his private capacity. My view is this, that number 1, the judges are well within their right to declare anything unconstitutional by dint of the office they occupy. But thankfully, there is an appeal process that needs to be taken. And why do I think the appeal process is important? It is important because, number 1, there is no clause in the Constitution up to this date, this moment, that gives a statement that says a state officer cannot initiate the popular initiative. If this ruling was in place before Uhuru Kenyatta came up with the BBI initiative, who would discuss the unconstitutional nature of his actions? Derotich Sei has said something critical, that up to today, there was no definite definition of what the basic structure, if there was in the Constitution, was. You cannot say that the president has breached Chapter 6 when the interpretation that you all had not entered the canon of Kenyan law up to the point you stated it. But the ruling in its extensiveness, and now I'm answering your second question, yes, was aimed at maiming and thoroughly mutilating the BBI process to ensure that even at appeal, out of 18 or so points, 1 or 2 would still stick, which is why some people argue that this was as much a political decision as it was a judicial one. My fear is this, that we are creating a precedent where there is a difference between the people and their representatives. It takes me back to the Constantine time where the church separated the difference between the laity and the clergy. So we are saying today that Uhuru Kenyatta is not citizen enough for Chapter 257, but he is citizen enough to be sued in his personal capacity. And I keep wondering, do we imagine that this Uhuru Kenyatta that we do not like, and I say we, quoting those who do not like him, will be president forever? We must ask ourselves, what then of the next president? When they build a road and it is ruled it was built without public participation, can I then sue the president? And how many times will the court have the president sitting in court, leaving the State House being personally sued? So we may celebrate this victory for now, but we must consider the very weighty issue of have we made it impossible to ever repeat this constituency and made every clause an eternity clause. Thank you, Mark. Bwana Wakili, please respond to that and tell me, can this judgment be set aside in its entirety? Is that a possibility?
You know, Ben, at times arguing between laymen, lawyers, it's really confusing, but I hope I remain on scripts in just arguing the law. It is very difficult to appeal, to sustain an appeal on all the 21 matters, to be very honest and fair. The 21 matters are weighty, constitutional matters, which on first instance, on an ex parte appeal, you can get a stay, a wholesome stay. And secondly, there is no court registry that is open over the weekend where I have seen something as a stay or a memorandum of appeal being banded around. There is no known registry in this country that is open, unless the Court of Appeal has gone back to their night sitting, which I think they should not go to. But going back to the issues that Mark Bichachi raises, there is a reason why the Constitution, when you approach Article 255, where we have the basic structure, those things that cannot be amended without, first of all, approaching the Constituent Assembly, without going the four processes, civic education, public participation, Constituent Assembly, and all those. There is a reason why the Constitution in 255 gave itself that list. Secondly, there is a reason why 256 is laid in place, Ben Kitili. The reason is this, so that the people who have power, the people in parliament, they can do whatever they want, but we gave them a certain limit. They can do it to this maximum. And when you come to 257, if Uhuru Kenyatta today wants to use the limp under 257, what he needs to do is to wait. The Constitution doesn't run anywhere. There is no urgency in amending the Constitution. It is not like there is something, the subject matter will not disappear. Right. So he has to wait his tenure to end. It is in the next 13 months. And then he can come, talk to Jerotich, Javas Bikambo, and convince us that as a Mwananchi, he wants to come and amend the Constitution. There is a danger why Uhuru Kenyatta and state officers are not allowed. Look at what he did when he had addressed a tribal meeting in Sagana. He gave our money, 4.5 billion, to the MCAs as an incentive to pass the BBI. That is our money, Ben. It is my taxpayer money, you and the other Wanjiku. What happened to Uhuru Okot? He walked the length and the breadth of this country with nothing. He used his resources. Why didn't we afford the Uhuru Okot a chance to give MCAs money? We are being told that at the National Assembly there was an inducement. I don't have the facts, but that is what is being said in these corridors. The question we need to ask ourselves, do we collect taxes to be used by those in power to change the law for what is an inconvenience to them? Look at the BBI critically. What we are changing is what Mr. Uhuru Kenyatta considers an inconvenience. It is not what the people consider an inconvenience. And secondly, the other question is this. For example, take one thing in that BBI. We need to be told and to be shown a document where Wanjiku sat down and said, for me to be peaceful with Anjuguna and Anatieno, I need a prime minister. Where was that? The third point that I'm making in finality is the issue of when we went around the country saying we were doing validation. The people who came and spoke in those rallies were politicians. Are you saying those are the only Wanjiku we have in this country? When they went to Mombasa, it was Raila Odinga and all the state officers addressing that thing. When they went to Meru, it was governors, Waiguru, and all the people there, Akina Murkomen. We didn't see Antere or somebody there addressing the people, saying in Meru, our problem is Mira. Do we need a prime minister for Mira to be sold to Somalia? The answer is no. We need to ask ourselves fundamental questions as a people. I don't need the position of a deputy prime minister for the price of maize in Tarbo to increase.
Good point. Let's move this forward. Jarvis, some people are attributing this to the frosty relations between the judiciary and the executive. How much of it would have had it to do with that? And what do you think the ruling was a bit harsh from the 5 judges? And what does it portend for the 2 arms of government moving forward?
Ben, the Constitution of Kenya is the Magna Carta of the Republic. And it must be approached with the seriousness that the people in antiquated biblical times used to approach the tabernacle. And when you look at this Magna Carta of the Republic of Kenya, that the Constitution is, you appreciate various provisions, including 159 that says that judicial authority is derived from the people of Kenya. It must not therefore be presumed that when the judiciary is making its determinations, that such determinations are being made against or contrary to the will and aspirations of the people of Kenya. The judiciary is taken care of or catered for in the Constitution. What the High Court did on 14th of May is provided for in Article 165, Subarticle 3 of the Constitution. It was doing its work. The issue of the frosty relations between the judiciary and the executive, as it has been presumed, this frostiness is not factual. This frostiness is political or politically instigated. You may recall, with the benefit of memory, that after the Maraga Supreme Court annulled the election of His Excellency President Kenyatta as the candidate of Jubilee, having been voted in as president, sentiment were, and it's on record, said that the judiciary shall be revisited. Fact on file.
Right.
Then we can say that that's where it began. It was political. So it was not a question of the executive in its nature having an issue with the judiciary. So it was politically instigated by such sentiment. Secondly, when the work of the judiciary is hampered by lack of financial facilitation that is adequate due to political interests, then also it flies in the face of the judicial authority, which is derived from the people. So which means that when you look at Article 1 of the Constitution that says sovereign power belongs to the people of Kenya, political games are being played against the interests of the sovereign.
Right.
It must not be deemed that only a section of the 3 arms of government properly represents the people. Yes, we know that nobody in the judiciary is elected, but their power is derived from the people. Legislative power as well derived from the people, and executive power as well derived from the people. Here, what we need to see, for instance, is that these 3 arms of government, which were the people of Kenya, we the people of Kenya gave unto ourselves when we embraced this constitution, must be honored and respected. The other third point that I need to make in respect to your question is that when the Judicial Service Commission had conducted its interviews to equip further the human resources at the judiciary by way of appointment of judges, such has not been done. And the exercise of executive authority of the president should have been done to make sure that these persons are appointed. They have not been appointed. The issue, this small issue of the rule of law also comes into question. That now when the JSC has done its part, is there really a reason as to why, for instance, the head of state should fail to do that which is supposed to be a forward movement or motion of the execution of the law?
All right.
So I think when we look at this, we must not embrace politics too much to the extent that then we end up constricting the liberty and the latitude of constitutional bodies or organs to do that which the people themselves wanted.
Right.
When you look at the very important exordium of the Constitution, that the people of Kenya aspired to have a government that is conscious and led by the rule of law, principles of equity, social justice, fairness, etc. These preambular provisions are not meaningless. They constitute the aspirations of the people.
All right.
And so today, the people in the executive power, legislative power, and judicial power, and we, the ordinary citizens, should appreciate that when we give a constitution unto ourselves, it is not just a piece of paper that can be spat on.
Right. Cherotich, are you worried, very quickly, are you worried when this matter goes to the Court of Appeal? There are people who have predicted doom that the executive will find a way of twisting, whether it's at the Court of Appeal or the Supreme Court. What is your prediction, very quickly?
Well, I don't think it is outside of the realm of possibility for there to be an attempts to intimidate and push back. I choose to remain optimistic today because we saw what happened on Thursday, that we have men and women of integrity, and we hope that the Court of Appeal bench will also view these matters with the same level of seriousness. But where I sit, I do not understand and see how the Court of Appeal will be able to overturn the judgments the judgment that was rendered. But I am worried. We have been worried. We have seen impunity. We've seen disobedience. You look at the slow and steady militarization and securitization of this country. When we have a military running Nairobi County, we have all kinds of, there's a feeling that anything can happen. And I think part of the collective shock on the part of the proponents of BBI is this idea that they thought Kifua will push them through anything they want. They just pronounce and they operate with impunity. In the same way the president thought he could enter door A as under Article 257 as a civilian, as president-elect, come out door B as the President of the Republic of Kenya, therefore with access to 256, and then chop and change and mix and match as and when it suits him. So there has been this high level of impunity, of saying, oh, whatever we want to do. Look at the orders that were issued on Miguna. How many years later is Miguna still sitting in Canada when court orders are issued? So it's not outside the realm of possibility, this disobedience. But we want to, as Kenyans, understand always that power belongs to us, right, that we the people are sovereign, and we want to believe that an independent judiciary will continue to look at matters objectively, using their jurisprudential lenses, and also having the ability to translate it to the lay people, because right, sometimes it becomes that battle of the legal voices and terminologies, and ultimately Wanjiko on the ground is saying wanasema nini and what are they trying to, but we have every hope and faith and belief that this time around the people will be sovereign and the Constitution of Kenya will be protected.
Bwana Wakili, given the way the Court of Appeal is constituted and the Supreme Court as well, what is your prediction?
First of all, Ben, we have to be real as we predict. Whereas there are a few things in the 21 orders that were issued that they might find some probable chances of success. But to say that they can have the whole thing overturned in total, I think that is stretching imagination far to the other end. But looking at the constitution of the Court of Appeal, it is a solid court. It is a court that jurisprudence has grown in nearly all facets of the law. But what we must now be careful as Kenyans is that when the five bench ushered us to what I'll call the Fourth Republic, the republic where Wanjiku matters, the republic where it is Wanjiku, then the rest, what we must now do is each Kenyan must actively participate to push forth the agenda that it is us. The ultimate voice lies with us. The judges at the Court of Appeal, they have a role to play, and that role is to safeguard the Constitution of Kenya. Right. The term of Uhuru Kenyatta will come to an end in the next 13 months, but Kenya as an enterprise is here to stay. So whatever ruling they will make, they must make it in mind, not of Uhuru Kenyatta and Raila Odinga. Right. Those are passing clouds.
Mark
they must make it in
Yes.
mind that Kenya must continue as a progressive enterprise.
Mark Bichache, 30 seconds only. The Kenyan democracy is based on, among other things, the independence of the three arms of government. What is your prediction as proponents go to the Court of Appeal and probably the Supreme Court?
I will use history to make this prediction. Number one, I highly doubt that the appeal process will be able to overturn all the 20-odd judgments that were made. But I also know that there are very strong terms, especially if you use Judge Matibo's rulings and rulings all the way back from 2007 to 2008 in the constitutional process then, that we will end up with some form of referendum, and we will end up very really with the question of answering what happens to the 4 million Kenyans that agreed to this. The 4 million fellow lay people like myself who have the ambitions envisioned within the BBI. The 4 million lay people like myself who disagreed that politicians should be completely outside of any form of public constitutional amendment.
All right.
And those things are within our rights as the lay people. The lawyers can argue people as they please.
Thank you. Thank you. Let's take another quick commercial break here on Inside Politics. We are still trying to dissect the momentous ruling made by the 5-judge bench of the High Court on Thursday night to nullify the BBI process. The proponents say they go to the court tomorrow. When we come back, we shall be getting into the political ramifications of it all. It has been closely tied to 2022 politics. What now? Stay with us.